further ado, I will put Professor Kumar up on the screen so you can all say hi to her and so that she can begin.
Hi, everybody. Let me share my slides here. And thank you for those of you who are here nice and early. I know how hard it is to tear oneself away from breakfast tacos. So what I want to talk to you about today is trial court specialization in patent cases. So patent law is a highly specialized area of law. Yet in the US judiciary, we have little technical expertise that is integrated into our system. And I should note that this is not the norm in other countries. So as part of this Fulbright grant, I researched how Germany and Switzerland both utilize what are called technically qualified judges. And these technically qualified judges have no law degree. They only have a technical background, and they help legally trained judges decide patent cases. And based off this study, I have recommendations for how the US could improve access to technical expertise for the courts. So the structure of my talk today, I'm going to very briefly talk about Europe's use of technically trained judges. I'm only going to spend a few minutes on that, given how limited my time is. Then I'm going to talk more about US patent specialization, and in particular, how US judges educate themselves about technical issues. And then finally, I'm going to talk about how the US could integrate greater technical expertise into the court system. So starting briefly with the European systems that I looked at. Germany is the primary example of using these technically qualified judges. They have a bifurcated patent system. And so what that means is infringement cases go to one set of courts, whereas if you're challenging the validity of a patent, that goes to the federal patent court. And what's unique about this federal patent court is that they use technically qualified judges without law degrees who sit on panels with the regular legally qualified judges. And depending on the type of case it is, you may have half your panel that is technically qualified, or maybe one of three judges is technically qualified. And these are really highly skilled. These technical judges are highly skilled. They have at least a master's, and many have PhDs in their technical area, 5 years at least of work experience in their scientific area, plus 10 to 12 years of work experience in the German patent office. So very highly qualified. Notably, these technically qualified judges only hear cases directly related to their technical skill set. So I mention this because it's dissimilar from what we have in the PTAB, where you might have somebody with a chemistry background hearing a case that's really more about engineering. In Germany, they actually assign cases based on the, based on the technical class area. Switzerland was another court that I looked at. It was established in 2012. Prior to that, patent cases went to the canton courts, and they modeled their court after Germany. A couple of differences: the Swiss patent courts hear both invalidation and infringement cases. All of these cases have a panel of 3 judges, one of whom is technically qualified. And some judges have both technical qualifications and law degrees. There are some quirks about this court. They rely very heavily on part-time judges, and I can talk more about that in the Q&A if people are interested. It can sometimes lead to strange conflicts of interest. But generally speaking, again, they're relying on technical expertise in all of their patent cases. I want to talk about some of the advantages that come out, or at least advantages that Germany and Switzerland were able to realize by switching over to this kind of a system. First of all, they found that it sped up the amount of it sped up the litigation time. So it made it much faster to litigate cases in both the German and Swiss systems because they weren't having to wait for an outside expert report. It made, you didn't have to spend time looking for neutral experts. So this made it a faster system for them. Also, another benefit that was found is that you have an integrated source of trusted expertise. It can be really difficult to find good experts on a case-by-case basis. It can take time to do that. And also, when you have these technical experts integrated into your court, these technically qualified judges, they develop the ability to explain technology to the legally trained judges in a way that the legally trained judges can understand. And this has been a major complaint from US district court judges that outside experts don't necessarily understand how to explain things well so that the judge can understand the technology area. Also, several judges told me off the record that there was a greater comfort level in terms of having a colleague being able to explain to you a technical point than having to ask an outside expert or a party hired expert. There are other advantages as well in terms of the cost of these experts is integrated into the litigation system. So in the US, judges might be reluctant to use special masters or technical experts because the cost gets shifted to the parties. By contrast, technically qualified judges are integrated into the system. So the cost is, kind of spread out in that regard. The government is ultimately paying for this. The number one benefit that I saw was that it makes neutral expertise the norm and not the exception. Under the current US system that we have, if a judge wants to hire a special master or a neutral technical expert, generally speaking, there's a hurdle that judge has to overcome. And part of it is just the judge has to acknowledge, like, this is a complicated case. This is something where, I need a neutral expert to help out. And part of it is just the fact that there's a lot of case law from the federal circuit that really just looks down upon judges hiring or judges utilizing, I should say, neutral experts. There are some disadvantages to the system, which I want to briefly touch on. It's expensive. You're basically, if you're trying to cover all the technical classes, then you need at least 6 technically qualified judges, or at least that's the German and the Swiss approach, where they have the 6 different technology classes that they have experts in. I'm not sure I personally agree with this, but a number of scholars have commented that there might be a risk of tunnel vision or pro-patent bias. So the tunnel vision problem is you'll have these judges who are only hearing cases in a very narrow area. And then that's going to, they don't have the broad perspective the way that our district court judges do, because they're only able to hear this one type of case. And that could lead to distortion in terms of the decision making. Some argue there's a risk of a pro-patent bias, that judges who have a narrow focus are more likely to become pro-patent over time. I'm not sure I actually agree with that, but I wanted to bring it up because some scholars have said that that's a risk. So let me switch gears then and talk a little bit about US district courts and their expertise. So first of all, it's worth mentioning that we do have a number of district courts that hear a high enough volume of patent cases that they could be called at least legally semi-specialized. I haven't gotten a chance to look at the most recent statistics, but it's roughly 60% of patent cases that get heard by just 5 district courts and roughly 75% of all patent cases that get heard by 10 district courts. So we have courts that have patent expertise legally. The problem is on the technical side. The judges, even in these more specialized district courts like Western District, Eastern District, District of Delaware, the judges generally lack technical backgrounds. And so they're forced to compensate. And how do judges in the US compensate? Well, there's a few ways of doing this. First of all, they can hire law clerks with certain technical backgrounds. That's not really a great solution, especially at the district level. You know, judges can't hire that many law clerks. And you can't, you get a loss of transparency when judges have to rely on experts in the form of their clerks who may only have undergraduate degrees, who may not have practiced in that area or worked in that area. Other options for district courts include hiring neutral experts. I briefly mentioned hiring special masters or neutral technical experts. Again, that's also difficult. The cost gets passed on to the parties, and many judges are reluctant to make patent litigation even more expensive than what it already is. Also, it can be hard to find good neutral experts. Some judges who hear a high enough volume of patent cases, they have maybe a list of experts that they know in the area that they can call on. But especially if you're a judge who's not, you know, hearing quite so many, or it's a technical area that you don't usually hear a case in those situations, you may not have a neutral expert offhand that you can just contact. Finally, again, the federal circuit has really looked down upon the practice of district courts heavily relying on neutral expertise. That can make it difficult as well for the district court to utilize special masters or technical experts. So as a result, the default ends up being party hired experts. And, you know, it's worth noting party hired experts, they certainly have their place. But when you're talking about like fundamentals, like fundamental technical information, basic scientific information, that's not a good place for the adversarial system. That's a situation where you really would want a neutral person saying, no, this is what this, you know, this is what these technical terms mean. This is what this area means, or this is, you know, the background information that you need to be able to interpret claim language. It can be really tough for judges with lay backgrounds or non-technical backgrounds to assess the quality of the scientific information that they are receiving. So that brings me to the takeaways in terms of, well, what can we do in the US system? So first of all, let me just say this. We've got, you know, the law clerk, you know, we have some who are using law clerks, so not many. We have a few who are using neutral experts, but mostly we have party hired experts. So one idea that I have is we could have technically qualified magistrate judges for district courts that get lots of patent cases. So what we could do is in district courts with a high volume of patent cases, we could have technically qualified magistrates who have law degrees, but who have technical backgrounds. And these magistrate judges could help in terms of providing technical tutorials for the judges, answering technical questions, plus doing things that magistrate judges do. They could oversee Markman hearings. They could provide preliminary opinions. It's worth noting some district courts are already doing versions of this. District of Delaware, Eastern District of Texas have been heavily relying on magistrate judges for patent cases, some of whom have technical backgrounds. Now, it's hard to directly compare the US system with the European one. So what my proposal would be is that we do a trial, that we choose one technical area, you know, say biology, say, you know, electrical engineering, and then have Congress provide funds for 5 or 10 district courts that have a high volume of patent cases to hire one patent magistrate judge in that technical area. Then we could assess, does this help improve quality? Does this help increase the speed of litigation? And if the small trial is successful, a bigger trial could take place and maybe it could be gradually expanded out. Now, obviously, there are going to be problems with this with regard to doing such a trial run. Oh, and I don't have a slide for this, apologize. So some issues that we could have are, it could be difficult to find legally, judges who are both legally and technically qualified in certain areas, such as electrical engineering. However, it's worth mentioning, first of all, that these patent magistrate judges could be part-time. It might make it easier to find people if you did it on a part-time basis. You could also have patent magistrate judges who get shared by neighboring courts, where, say, a judge splits his or her time between, say, District of Delaware and District of New Jersey, for example. But that is one potential problem. Another potential problem, there could be over-reliance. Judges may rely too much on the magistrate judges. A solution to that, though, I think would be if you only have this in courts with high patent dockets where the judges are savvy and they are used to hearing patent cases. I don't think this should be any worse than what the Federal Circuit does, which is very heavily rely on law clerks with technical backgrounds. I think sometimes the Federal Circuit likes to insult the intelligence of the district court judges by claiming that they're going to overly rely on technical expertise when the Federal Circuit themselves relies heavily on their technically trained clerks. An alternative to this that's less ambitious would be to use technically trained staff. That would be cheaper. Again, we could have Congress providing funds to a few district courts to hire technically trained staff in one or more technical areas and see if this improves the quality and speed of litigation. This is an approach taken by a number of foreign patent courts. For example, Japan and Taiwan both rely on technical staff. The problem I see with this is it's just not quite as useful. They can't, if they're not legally qualified, if they're not magistrates, then they can't do as many things as what a magistrate judge could do. Also, there's less transparency and accountability when it's staff. With a magistrate judge, there's some amount of transparency. A magistrate judge issues an initial findings and decisions which can be appealed to the district court judge. When you have staff, it's less transparent. It's more the black box problem that we have with judges relying on technically trained law clerks. I also have a more ambitious proposal that I'd like to mention in the last few minutes. So we informally already have most of our patent cases going to a handful of district courts. So my question is this: why not formalize it? Or my proposal is, why not formalize this? Why not have all the patent cases go to 10 or 12 different district courts and have them, concentrate that so that then we could make it feasible to have in-house, either technically trained staff or technically trained magistrate judges who can assist with patent litigation. Now, note, I'm going to say something which I think would be very controversial with some judges. I think that if we set up a system like this, that it's critical that, first of all, we ensure geographic diversity. Like ideally, you would want to have one of these patent courts in every circuit. And this is going to be the really controversial part, I think we have to make sure these are in easily accessible places. So I am not a fan of let's fly to DFW and then drive to Marshall, Texas, as terms of accessibility to litigants. So I would propose that the courts that get chosen for this are near major airports to make it easier for litigants to access the court. But the goal of this would be for every patent case to be heard in a court that has ready access to neutral technical expertise, whether that's staff, whether that's magistrate judges, to help improve the quality of the litigation. Now, note, we could put safeguards on this. One safeguard we could use is we could cap the time, we could cap the amount of cases that an individual judge hears in the area of patents, or a percentage of their time that they spend on patent cases. The reason I would suggest a cap of some sort, like 50%, 25%, would be to avoid tunnel vision. Because I do think a major strength of the US system that we don't want to lose is the fact that these judges have a broader perspective because they hear cases other than just patent law. Also, I think that if we had a cap, it would make it easier to avoid tunnel vision. It would ensure just general higher quality of our cases. So an alternative to this would be each circuit gets a designated patent court, where if a judge in another district gets an unwanted patent case, we could allow the judge to transfer it out to the designated patent court. That would be a different option if what I propose isn't feasible. But I'm going to conclude there so that I can leave some time for questions and answers. I'll mention that if you're interested in reading more about this, I have the full study published in William and Mary Law Review, and you can take a look at that. But with that, I'll conclude, and I'd welcome any questions.
Thank you, Professor Kumar. I guess I'll have to relay questions out to you, but let me know if you can see people in the audience. So we're happy to take questions for Professor Kumar. We got one over here. And let me know if you can't hear them, Professor.
Sure.
Yes, Professor, can you hear me?
Yes, actually I can.
Yeah, thank you for speaking to us today. What I was wondering is, I'm not sure the countries you mentioned, such as Germany and Switzerland, I'm not sure if they're using juries in their cases or not, but in a system like ours, where it's really a jury of lay people making the factual decisions, does technical expertise on the part of the judge and his staff really make as much of a difference?
So that's a good point. No, they are not using juries, and that is definitely a difference between our systems. That being said, we have, outside of the jury context, the judge still has to make decisions that are questions of law. There is still the Markman hearing, there is still claim construction, there's still all of these issues where technical expertise is part of the decision. And actually, I didn't get a chance to mention it just because of the time, but that's why I don't think we should go as far as what Switzerland and Germany are doing. Like, we don't need technically qualified judges who are equal, on equal footing to legally qualified ones, because our system is different. But I do think it would still be useful to have something like staff or magistrate judges with the technical backgrounds in terms of the Markman stage of things, in terms of just giving the judge the basic, giving them an accurate source of the background information that the judge needs to help them better understand the case. So you were absolutely right to point out the differences. That's why my proposal is quite different from what the foreign courts are doing.
Thank you. Yes, we have a question from Pierre.
Good morning, Professor. You mentioned that you're concerned about tunnel vision by district court judges who have a heavy concentration of patent cases. Do you have the same concern about the Federal Circuit, whose docket is dominated by patent cases? And if so, would you be in favor of sending those cases out, or those appeals out, to the regional circuits as well?
So it's a great question. Let me tell you what my ideal system would be, and then let me tell you, given what our constraints, what I would say. So ideally, like, were we starting this system from scratch, this is what I would say. Let's super specialize the district courts, like in terms of the patent cases, like let's just have a national patent court or several national patent courts that only hear patent cases. And then let's have it go up to general courts of appeal, because generally I think that the specialization should be at the trial court level, and the general part of it should be at the appellate court level in terms of good decision making. We don't have that system, however. So given that's the case, I have to say that I am sympathetic to Professor Duffy's proposal of maybe we should have, say, 3 courts of appeals that hear these cases, so we have a little bit of diversity of viewpoints with regard to ensuring good decision making, because I do think we have examples in the past of where the federal circuit's kind of gone a little bit awry. Now, admittedly, the Supreme Court nowadays has taken a much more active interest in patent cases. So it's not as bad as it was back in, the 90s and 2000s when, the federal circuit was sort of the end all for patent cases. But yeah, ideally, like, I wish we had a system where where it was actually super specialized at the trial court level and then less specialized at the appellate.
Thank you. I think we have time for one more question. Yes, please.
Good morning, Professor. I was wondering if you see your proposed magistrate judges as more specialized than PTAB judges, or if you could see some kind of loan system between the USPTO and the federal courts.
So the PTAB specialization is really interesting because, on one hand, you have these PTAB judges being hired from a variety of backgrounds. But then on the other hand, there's evidence that there's all these PTAB proceedings being heard by judges where there's a mismatch in terms of what the PTAB judge's technical background is and then the case that they're hearing, such that it's not really as useful that they have that specialization. Ideally, what I would love to see is, we have just our handful of patent courts in the US. We could quibble over the number, but let's just say 10. So not quite one for every court of appeals. And then there, with a smaller number of courts hearing the patent cases, then we could have a number of magistrates with different technical classes. If we did do that, then that would mean we have more specialization in terms of things like Markman hearings than, compared to what's going on in the PTAB. But I don't think it would be unreasonable in the sense that you would still have district court judges overseeing things, district court judges who hear cases other than patents and who have that broader perspective, and who ideally were confirmed because they could hear a wide variety of cases and not just patents. And I feel like with having that, it will ensure that we don't have tunnel vision. And I'll stop there because I see that I am out of time.
Okay, thank you so much, Professor Kumar. Let's get a round of applause.
Thank you.
Thank you so much for joining us.